pressure mounts for Justice Minister to follow through on her commitment to make the sex offenders register public. Now, in January, Minister Mmamoloko Kubayi promised to reveal the names of all people convicted of sexual and gender-based violence, the GBV. At the end of February 2025, we have roped in Nothemba Sonjica, legal officer and current acting manager at the Chairperson's office at the Commission for Gender Equality. Ma'am, thank you so much for your time. So there was a lot of anticipation and expectation that today we would likely see the release of that sex registrar. The deadline for the release was meant to be today, but now the understanding is that it will be a phased approach. Just speak to us about what you know and also just the reaction around the expectations that were carried out in January.
Thank you, ma'am, for having me. The advocacy regarding the publication of the sex offenders registry is not new. It's been there for a while now. There have been calls for the register to be made public. So as the Commission, we were also looking forward to seeing whether the ministry would go through with the undertaking to publish the register today, as it's been years in the pipeline. So as the general public, we're also waiting to see how this program will be phased out and how the public will be allowed access.
We also understand that, some of the concerns, and as you rightfully put it, I mean, this list had been available to those that predominantly deal with children. However, I think the issue now was that it was meant to then be released today. I think it's the first time we had a definite deadline, but it was not to be. Just weigh in terms of the importance then of releasing such a register to the public, especially given the concerns around GBV in this country.
It's very crucial, ma'am, because previously the register was only open to employers and certain classes of people, NGOs, or people that required certificates or licensing. If it is open then to the general public, it means communities and individuals will have access to this information, which will then encourage safety and protection. It will be some form of a safeguard for the general public, having this access to this information, being aware in their community who they live amongst. The access to information will also allow individuals, groups, employers to have free access to this information without having to apply, because previously they would have to be applied. The administrative process was lengthy. So if access is then open to the public, then there would be no need for the lengthy applications for the public employers to have access to this information. There are many benefits and safeguards that will come with it.
And just given the legalities and identity concerns here around releasing, one would imagine the names of the perpetrators as well as the addresses of these perpetrators. Just speak to us about, how that will likely infringe or maybe not the POPI Act, the Protection of Personal Information Act.
All right, ma'am. I think the challenge would be balancing the right to privacy and the right to access to information, of which the information regulator would be the custodians. But remember, all rights in terms of the Constitution are limited. I think establishing and analyzing the context of releasing this information, the justification behind it is important as well. And as the information regulator in terms of the POPI Act states, there are certain limitations as well and exclusions as well. I think this would in particular be a part of the exclusions when we look at the justification behind the publication of the sex offenders registry. So even though there's the right to privacy involved, there's also the right to access information. Yeah. So those rights need to be balanced.
Yeah, and when we're talking about balancing those rights, because the understanding here are these are convicted perpetrators, so they have gone through the system of the law. So what then would be the considerations here, particularly as you've also rightfully put it, the right for children's protection is also important. I mean, there was a report, I think, sometime last year that identified that there were around about 16,000 officials within the Department of Education that had criminal records. The number, of course, in terms of how many of those have sex offenders or sex abuse allegations against them isn't immediately known. But that is of concern when you consider that these are spaces where there are children.
Yes, ma'am. The balancing of these rights would only come into context with regards to the nature of the information shared. Obviously, we will establish these people have been convicted. That has been established already. But in the context of the information shared, including the ID numbers and the addresses, then would have to balance that right to privacy with the right to access to information and the right of prevention against all forms of violence when it comes to children. So we'll have to look into those competing rights. In fact, already it has been established that we need to protect our children and the disabled, because the register only applies to children and the disabled. Hence, there has been arguments for it to be extended. So the protection of children and the disabled must take priority. However, in terms of balancing that right with the right to privacy, then the information regulator will have to come in and say, if this register is published, this is the information that needs to be distorted, but this is the information that the public needs to access in order for these safeguards to apply.